Welcome back to the channel, everyone, and buckle up because today's Courtroom Showdown is one of the most intense probation hearings we've covered yet. We're diving into the case of Devon Atkins, who's on probation for a third-degree felony involving injury to an elderly person. And trust me, this hearing spirals fast. You're about to see a probation officer break down repeated violations, missed mental health treatment, no-shows to mandatory appointments, and alleged contact with a protected victim. Meanwhile, the judge is piecing together a pattern that reveals far more beneath the surface. So stay with me, because the twists, the tension, and the final sentence are absolutely jaw-dropping.
All right, ma'am, are you Devon Atkins? And Miss Atkins is on probation for the third-degree felony offense of injury to an elderly person. That's started at May 23rd of 2022. There was a motion to adjudicate probation filed. She entered pleas of true to counts 4 and 5. Does the state have testimony with regard to counts 1, 2, and 3?
Yes, if the court would like.
Yep, I think I would.
Down there, call, Ms. Shakita Cole.
Yes, ma'am. Good morning, Ms. Cole. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Ms. Cole, would you please state your full name for the record?
Shakita Cole.
How are you employed?
I'm employed at Jackson County Adult Probation.
And as an adult probation officer, is it your responsibility to supervise an individual on this court's probation by the name of Devon Atkins?
Yes.
Do you see Ms. Atkins in the courtroom here today?
Yes.
Can you point to her identifier?
Right here in the blue jumpsuit.
Your amended record reflect Ms. Cole has identified your probationer Devon Atkins.
Record will so reflect.
And Ms.
Printing.
Cole, as with every probationer, when they are placed on the court's probation, are they given the rules and restrictions placed upon them and what they are supposed to do to follow the court order?
Yes.
And each one of those in detail is gone over with them so that they understand everything that they're required to do. Correct?
Yes.
Was Ms. Atkins so advised?
Yes.
At her intake?
She was advised at her intake and at a TTM at the Milton Center in person.
Okay, and describe for the court what a TTM is.
A treatment team meeting.
Okay, so in your opinion, Ms. Cole, as her probation officer, was Ms. Atkins fully apprised and aware of what she was required to do on probation?
Yes.
And were in fact a majority of those things intended to help her?
Yes.
Was she advised that she was to report to the Community Supervision Department when directed by yourself in the court?
Yes.
And did Ms. Atkins, based on your review of the file, fail to do that on multiple dates, including but most likely not limited to November 4th of 2024, November 19th of 24, and, and was that in violation of her probation order?
Yes.
Did you address that with her and inform her, it is important to report, if you have something come up, you need to let me know?
Yes.
And did she do that?
No.
This moment right here is huge in the case. Notice how Miss Cole, the probation officer, is listing violation after violation, failures to report, missing community service documentation, and not updating her address. These are not minor technicalities. They are foundational requirements of probation. Judges rely heavily on probation officers' documentation because it reflects whether the defendant is genuinely trying to comply. And then we get a bombshell. Ms. Cole says Atkins refuses to address mental health issues and missed appointments scheduled specifically to help her stabilize. That detail matters because mental health treatment can be a major factor in whether a judge chooses rehabilitation or revocation. What do you think, viewers? Is this sounding like willful neglect or someone who's overwhelmed and struggling?
Was Ms. Atkins, as a condition of said probation, ordered to perform community supervision hours?
Yes.
And and to report those to you?
Yes.
Obviously, if you do not know that she has completed them, even if she has, is that a violation of her probation?
Yes.
To your knowledge, based on your review of her file and your supervision of her, did she either complete the hours or immediately report to you? Sorry, I'm reading that. No wonder everyone's looking at me.
I was about to say, I know, I was about to,
Community service. Well, that is in fact a condition of probation, right? Is it also a condition of probation that she is to report to you as to her address and so that you know where she is all the time?
Yes.
And if she does not do that, is it impossible for you to locate her?
That is correct.
Did she, in fact, immediately report to you her current address?
No, she did not.
Anything else? I know you and I have had a lengthy discussion about her that you feel would be appropriate for the court to know in conjunction with your testimony and your updated PSI.
The main thing is her mental health. She refuses to address that. We've made appointments for her with Spinal Tap, and she didn't attend the appointments. She's 100% when she was out unmedicated. So that kind of interfered with her completing her services. And she maintained contact with the victim in the case. So that part, her grandmother was trying to be there for her because of the mental health difficulties. And that's the main thing that we were trying to get her to address.
Okay.
Can I address anything?
In a minute. Mr. Lewis, do you have any questions? Hold on, ma'am. You're going to get an opportunity, okay? Mr. Lewis, do you have any questions of Ms. Cole?
Just briefly, during your supervision of Ms. Atkins, were you able to supervise her at points when she was on her medication and not on her medication?
The entire time she has not been on her medication.
So she's been unmedicated this entire time?
Yes, sir.
Your supervision? Okay.
Anything else?
Nothing else.
All right. Thank you, Ms. Cole. Any other witnesses with regard to the allegations? Based on the testimony,
Unless I may ask, Ms. Cole, Judge,
Yeah.
and you stated that earlier, Miss Evelyn Thibodeau, I believe that is her grandmother, correct?
Yeah, respectfully.
hold on, ma'am.
At some point in time in November of 2024, was Miss Atkins violating the condition the court had imposed that she not to have contact with Miss Thibodeau for Miss Thibodeau's safety?
Yes.
Thank you, Judge.
Okay, pause for a second, because this is a critical turning point. The judge directly confirms that Atkins had contact with the victim, who in this case is her own grandmother. When a court orders no contact, that's not a suggestion. It's legally binding, especially in cases involving injury to an elderly person. Now, it's clear the grandmother may have been trying to help due to mental health struggles, but in the eyes of the law, even mutual contact breaks the rules. This is where emotional reality and legal reality collide. A lot of defendants misunderstand this. Even if the victim initiates, the defendant must refuse contact. Do you think the judge should consider the grandmother's intentions? Or is a violation a violation?
Any questions about that? About
No.
the count, that's count 8 with the
Right.
contact? Okay. Then, at this time, based on the testimony, I am going to find count 1, 2, 3, 6, 7, and 8 true. Again, there were pleas of true to counts 4 and 5 previously. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, ma'am, Judge.
Any additions or corrections to that report?
No, from the bench, Judge.
Nothing from the state, Your Honor, unless Ms. Cole has something to add.
Do you have anything to add that's not already in your report?
No.
So the main thing I want to make sure, Ms. Cole, I have a notation here to ask is, you guys were aware of mental health issues and had opportunities for Ms. Atkins to participate in mental health services. Is that correct?
I made the appointments myself for her.
Okay. All right. Argument, Mr. Lewis?
Well, Judge, I think definitely from the updated PSI we have, as well as I think there was some issues from the jail. If you look at those issues and activity, I think that goes directly to her mental health state. Unfortunately, she has not been on a mental health caseload. I think that definitely would benefit her, as well as, being able to take advantage of any services that Spindle Top MHMR may have, or any programs that probation deems appropriate for her. I have had conversations with her, and meaningful conversations with her, where she has addressed to me her desire to take advantage of those activities if those available to me. She did understand that she had the safety opportunity that didn't go well, but I don't think the mental health issues were addressed, mainly just substance abuse at that point. I think if we can get a handle on that, or get some work done with her to address the mental health issues, I think she'll do a lot better in this situation and can be able to complete this
I
assessment.
mean, it's hard when
Hold on.
someone's not taking patients.
Well, it sounds like you had appointments that you missed that Ms. Cole made for you. Did she go to regular Safe P or special? Hold on.
Special needs.
So she's already been to special needs Safe P. So that was a whole 6 months plus aftercare of drug and mental health help. So Ms. Atkins, the problem is you're being given all the opportunities.
Yeah, but like I said, I don't know if I told you, I had an appointment in Port Arthur because I cannot get into Bowman. They're not taking new patients.
So you had an appointment that Ms. Cole set for you, at least one, how many?
Yeah, but it's not for medicine. It's for psycho. I'm not a psycho. I don't have those problems. I mean, some people do that. I don't know.
Well, you obviously we don't know what you need because you won't even go do the evaluation. That it sounds like you haven't been on medication that would be what?
Evaluation where?
At Spinal Top.
That's what I'm telling you. That's not, I don't have that. I'm not a psychopath. That is for.
It's psychopath. Nobody's saying you're a psychopath, but you have.
It's called past program. I'm not a psychopath.
That's not what it's called, and that's not the reason it's called that. Okay, if you had gone to your appointment and talked to them, then you would know what that was for, and you would know that it was meant to help you so that you could get on medication, stabilize, and not have the issues that you've been having. I'm going to find that you previously entered your. I'm sorry, Ms. Malfino. Did you have anything to add?
This exchange is honestly hard to watch because the judge and probation officer are repeatedly trying to steer Atkins toward mental health evaluation, and she's repeatedly rejecting it. The judge explains that the program isn't calling her a psychopath, yet Atkins continues interpreting it as an insult rather than treatment. This type of resistance is very common in cases involving untreated mental health conditions. But here's the legal twist. Once the court documents multiple missed appointments, multiple explanations ignored, and even a competency evaluation confirming she can understand instructions, the judge has little room to justify continued leniency. Let me ask you, is this refusal coming from misunderstanding, fear, or defiance? And how much responsibility should the court place on a defendant to recognize their own need for help?
No, Judge, I think that from my conversation with Ms. Cole, she's been gracious enough to offer to continue to work with her because I think she clearly sees the mental health issues. But as you can see, what Ms. Cole has been having to deal with is how the court has had to deal with Ms. Atkins today, and it's been kind of just this runaround circle.
Well, and in addition, I am going to find judicial notice of the court's file. Ms. Atkins was evaluated for competency to stand trial not that long ago. I think it was in January of this year. And I have that report. And the finding is that Ms. Atkins is competent, understands the nature of the proceedings, and is then just really making a choice not to follow through with what programs have been given to you, Ms. Atkins, to try to help you. So at this time, any recommendation as far as?
I have one more thing to say.
Okay.
She is not giving me the information needed to follow up with those type of things.
Okay. Well, I don't believe you.
Them.
I don't believe you.
You
Ms. Cole would never say go do something and not tell you where to go or help you get there.
No, she says she does not have a list of the community service.
I'm not worried about your community service. I'm worried about your mental health and the fact that you're not doing what you need to, and you're still contacting the victim, and it's a serious case. And so I got to protect society, unfortunately, because you're not choosing to do the things that.
I was gonna die, so I really didn't have much of a choice.
Okay.
It's my life in jeopardy.
I'm going to find that you entered your pleas of true to counts 4 and 5 freely and voluntarily. Again, I'm finding counts 1, 2, 3, 6, 7, and 8 true. Find sufficient evidence to find you guilty, and at this time, find you guilty.
When the judge interrupts and warns Atkins that talking over the court could add years to her sentence, that's not theatrics. That's the judge signaling that the hearing has shifted from discussion to formal sentencing. At this moment, the judge is no longer assessing potential rehabilitation options. She's assessing risk, compliance history, and courtroom behavior. Notice how the judge ties everything together. Repeated noncompliance, refusal of mental health resources, continued contact with the victim, and now an inability to remain respectful during sentencing. Judges look for accountability, and sadly we're seeing the opposite. If you were in the judge's position, would you see any remaining grounds for probation, or do you think incarceration at this point is inevitable?
Don't talk
I would
over.
like to look over.
I'm about to sentence you to prison, and how you keep talking over me is about to start adding years onto that. Stop talking. It's just going to get worse. Do you understand? Okay. I'm going to find sufficient evidence to find you guilty, and at this time, I'm finding you guilty of injury to an elderly individual. Sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. No.
I'm telling, like, she thought, like, I could not get up there.
I'm going to hand you the trial court certification that shows this
I would
was
like to speak to a detective.
this was not an agreement, and so you waived your right to
said
appeal. I need you to sign that
I
with
gave you
her.
hospital papers. I gave her everything.
I'm also
I had
handed
a
you.
doctor's appointment and everything. That's what I'm
I've got
telling
5
you.
more years that I could add on to that.
Oh, man.
I can give you up to 10.
Have 'em.
You need to stop talking so I can finish what I need to do, okay?
I'm telling you, I'm not guilty. That's what I'm telling you. I did not have a choice. I went to the hospital and everything.
I'm handing you a
3
written
times.
admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered
I
against.
don't have a gun.
I'm not, just listen to what I'm saying. If you'll listen for a minute, you'll understand. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
I don't have a gun, man.
Good, then you
You're
don't.
talking to the wrong person. I'm Devon Atkins. I don't have a gun.
I'm required
No,
to
I'm
read that
telling
to
you, I don't
everyone.
know what you're talking about. I don't have a gun.
Good, then you don't have to worry about that. Go back with the bailiff.
Thank you. I didn't find any pictures.
And that concludes this intense and emotionally charged hearing. Let's summarize. Devon Atkins was on probation for injuring an elderly individual, her grandmother. Throughout her supervision, she failed to report, didn't complete or document community service, refused mental health services, and continued communicating with the protected victim. Despite multiple opportunities and accommodations, including appointments personally scheduled by her probation officer, Atkins struggled to comply. Ultimately, the judge found the violations true, determined that rehabilitation efforts weren't being utilized, and issued a 5-year prison sentence in the Texas Department of Criminal Justice. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.